My name is Amanda Sanford, and I moved back to Prince Edward County in 2020 to be closer to my family, my roots, and my heritage. I feel like I might have been the last person to get an apartment for under $1,000 in Picton, but where it started as is a far cry from what it became after such a relentless dispute. As a tenant in Ontario, I did not pay rent for 3.5 years. I accumulated $35,000 worth of arrears. I am currently in compliance with the LTB order to pay back $15,000 to avoid asset seizure and wage garnishment. Tenants who are out here taking advantage of landlords aren't out here talking about it, and they're certainly not out here paying their arrears. And in most cases, landlords will never be able to collect the arrears that a tenant owes, and it can cost them hundreds of thousands of dollars. No good landlord should ever have to wait years to recover rent they are lawfully owed. 3.5 years to resolve a dispute is unacceptable. If the Charter of Rights and Freedoms indicates that it's not acceptable for criminals to be delayed through the court system, then how is it okay for landlords and tenants who are facing housing insecurity and economic uncertainty? I also want to start a conversation about what unhousing looks like for the missing middle here in the county and in Ontario. I'm doing this to raise awareness for what hidden homelessness is because it affects anyone who is, has, or ever will experience housing insecurity. And it isn't obvious because my parents' basement looks like this. Every landlord and every tenant in Ontario deserves equal rights and access to those rights within a reasonable time. Let me be clear, during this process, I obtained adequate and professional legal counsel, but when the other side refuses to play fair and you don't have unlimited funds, that's only going to get you so far. I have had 4 LTB hearings. The landlords have withdrawn my application twice, lied to the landlord tenant board to obtain an eviction under an L9 application, which doesn't set precedents for an eviction unless a tenant does not pay the rent they are ordered to pay. I am doing this to raise awareness on adequate housing, forced evictions, universal human rights, and housing rights for everyone. This isn't something that everyone will understand, and it leaves you asking more questions than obtaining answers. I won't be responding to comments because I expect scrutiny at the highest level, so please be kind. This is only the beginning of a story, and one video doesn't even begin to scratch the surface. So before passing judgment, I simply ask that you hear me out for 10 minutes and listen to understand where society is failing every landlord and every tenant. There's only one circumstance under which a tenant can lawfully withhold rent, and this was it. This is a universal human rights framework called the right to adequate housing and freedom from forced evictions, which ensures security of tenure. Section 12 of the RTA stipulates that every lease entered to on or after June 17th, 1998 shall have the landlord's name and address, and that it must be signed by the landlord. And until a landlord has complied with such obligations, a tenant's obligation to pay rent is suspended, and that the landlord shall not require the tenant to pay rent. Once during a tenancy, a tenant may request a written lease that complies with Section 12 and is signed by the landlord. And if a landlord has not complied within 21 days, a tenant may withhold rent. Section 12 indicates that a tenant can only withhold 1 month's rent, and that once a landlord has provided a signed lease, a tenant can no longer withhold rents. This section also stipulates that a landlord may require the tenant to pay the landlord rent payments withheld only if the landlord complies with the tenant's demand for a proposed tenancy agreement within 30 days. By way of the RTA, not signing a lease alone is not reason enough to void the tenancy agreement. There must be some other factor in which a rental contract may be considered breached or broken. For example, as per Section 38, a 1-year lease is deemed to renew after that initial term on a month-to-month basis, along with the terms and conditions prescribed in that lease. So if a lease agreement includes a built-in washer and dryer, a built-in dishwasher, and a built-in microwave as inclusionary in the rent, then refusing to reconcile the leased items is indication of further intent to breach a contract. Otherwise, this fails to meet the principles of contract law and draws to question the contract's legality. The Section 12 requirements that I'm referring to for a lease that is signed by the landlord and requires their address is as per the amendment made via Bill 124, the Rental Fairness Act of 2017. No good and reasonable landlord should have to wait 3.5 years to collect upon the rent they are lawfully owed if they are doing everything in accordance with the universal human rights and upholding their obligations under the RTA. The rights of a tenant are equal and opposite in that no good and reasonable tenant should have to wait 3.5 years to conclude an LTB matter pertaining to a person's right to adequate housing. Delayed justice is not justice. It denies a person access to the laws which are put in place to protect all parties involved. Dodging accountability is a defense by delay. Under the Canadian Charter of Rights and Freedoms, everyone who is charged with an offense has a right to trial within a reasonable time, and that other Canadian legislation provides some residual protection against state caused delay in limited circumstances. The primary purpose of Section 11B is to protect the following rights of individuals accused: A, the right to security of the person; B, the right to liberty; and C, the right to a fair trial. The provision also serves secondary societal interests: A, the interest in protecting the right of an accused person to humane and fair treatment; and B, the interest of having laws enforced, including through ensuring that those who break the law, are tried in a timely fashion. Jordan's principle has established that the threshold for a reasonable time in provincial court is 18 months, unless you agree to an 11B waiver. Furthermore, this specifically references delay that is caused solely by the conduct of the defense. The 11B principle is for those who have been charged with an offense. What this means is that my superintendent, who was charged with an assault, was charged and discharged under his 11B rights in half the time that it took for this to be concluded at the LTB, despite me making offers and payments to propagate a conclusion with an unreasonable ownership, because tenants and landlords do not have special mention in the Charter of Rights and Freedoms. During the course of my eviction and these delays, the landlords refused to provide property management services for me, in particular, refusing to moving snow where it was being completed prior to all of this nonsense, and where it is their duty to do so in exterior common areas, with the reasonable understanding that their actions may cause bodily harm. During the course of my eviction, I experienced a local business owner drive a snowplow into the snowbank I was standing in 3 times, while neighbors came out from their apartments to create what they called was a cause to evict me. I was assaulted by the superintendent during his duty to remove snow. He illegally entered my apartment without written notice to commit such an act. As the person responsible for property management, it is reasonable that he is aware of such requirements. A neighbor has been charged for damaging my property after I put cameras up as my only line of defense against a community that is dead set on dragging me through the mud. They fail to understand that a person withholding rent under Section 12 is a person exercising their rights under the RTA, and that this is a legal remedy under which a tenant may seek relief by raising issues such as tenant rights or maintenance under Section 82 of the RTA. Besides, what business is it of the neighbors if my rent is paid or not? The application my landlords made was an L9 application, not an N5 application or an N8 application, both of which were options at any given point that the landlord could have filed. It is an offense under the RTA for a landlord or representative to knowingly harass a tenant or interfere with reasonable enjoyment. A person is guilty of offense if they enter a rental unit without given written notice. No one has the right to harass, hinder, or obstruct a tenant in the exercising of their rights under the RTA. And if they fail to pay you interest on your last month's rent deposit, well, that is an offense as well. None of this has ever been enforced, despite Bill 97 increasing fines for offenses, especially for corporate landlords, to a maximum of $500,000 per offense. When disputes like this go on for 3.5 years without trial within a reasonable time, there comes a point where this becomes a matter of community safety. Under the Community Safety and Policing Act, there is an obligation for police to uphold human rights. In my case, the police have failed to recognize the right to adequate housing, freedom from forced eviction, and security of tenure as enshrined in Canadian human rights. So, is this really adequate policing? Within the confines of the criminal code, there is criminal breach of contract, willfully causing events to occur, and fraud by way of deceit, falsehood, and the intention to defraud me of property or valuable security. Regardless of the dispute, both tenants and landlords have access to the laws which are in effect at the time events occurred, and human rights upholds that value, including trial within a reasonable time. Landlords have more money at their disposal and therefore can afford more access to legal services and the laws which apply or can be manipulated to gain an unfair advantage. For that reason, tenants' rights are in effect priceless, but are of equal value to a landlord's right to profit. A fair and just society cannot protect one human right by sacrificing that of another. We need housing laws that uphold the dignity of tenants, protect responsible landlords, provide timely justice, and strengthen public confidence in our institutions. Equal rights require balanced laws, and balanced laws create safer, stronger communities. This starts at the municipal level. It is the responsibility of the municipality to ensure that these human rights are being upheld in their bylaws. This is why, for example, some municipalities are implementing renoviction bylaws, or why here in the county, short term accommodations need to be licensed and have been subject to moratorium. Long term rentals, however, are not subject to the same scrutiny, and it has created a gap in our legal system. So, if a complaint is made about the structural and environmental hazard of a rental house is made to the municipality, it is their responsibility to ensure that the complaint is addressed in a fair and honest way, as it is a matter of public safety for all occupants. Even if they aren't complaining about it, they aren't aware of the severity. All professional engineers are accountable for public safety, and if they cannot be, then the municipality must ensure engineers are meeting their own professional code of conduct. I have demonstrated knowledge of local history along with local knowledge of building methods and materials. I have identified the underlying root of the problem wherein buildings that have been used for antique agriculture are not suitable for human habitation. Barns like this are structural hazards and not built to withstand wind and seismic loads. Remember that the term affordable is not a universal term. Affordable is something that means something totally different to each and every individual. No matter how much or how little money you have, what you can afford is dependent on what you have in your pocket. If laws are written in a certain way, you can only expect certain results. Laws aren't robust enough to uphold the value that every person deserves their right to dignified housing and profitability. Think about that when you rent a place.